I'm Mark Mazzara, and I'm the director of the Columbia Institute for Ideas and Imagination. I want to welcome you all very, very warmly to this, which is our first event of the new year. And before I introduce tonight's speakers, I just briefly want to say what the Institute is. The Institute is an initiative of Columbia Universities that opened its doors last year, that brings together scholars and creative artists of all kinds, primarily in the belief that scholars could do with becoming less parochial and more imaginative in the way they communicate ideas, to be blunt about it, but in general that it would in fact be to the mutual benefit of these two groups of people who are all engaged in the business of thinking and communicating ideas, just to be able to do their work side by side and to have conversations and to see what came out of this. And we've had 1 year which produced some wonderful results and is producing work that is continuing to come out. And we're now embarking on the second year with a new class of fellows, most of whom are here. And we're very, very excited to see what happens. For those of you who are new to Reed Hall, the events of the Institute focus around the Rendezvous de l'Institut, which take place on Thursday evenings, and there is a program at the end that will tell you what's going on. And the first rendezvous will be Bill Sharp on October the 3rd, who will be answering a question that you've often asked yourselves, which is, what does walking look like? So do come to that and pick up the list, and we look forward to seeing you at other events. Whenever I stand on a stage, the technology goes wrong. It's a very mysterious thing. It's an infallible law. Okay, so it gives me enormous pleasure tonight to welcome Katharina Pistor and Matthias Thiemann. I was just remembering, Katharina and I were members of the same faculty committee back in 2012 and 13, out of which the idea emerged to create the Institute. So for both of us, it's been a fantastic journey over 6 years, and it's an enormous pleasure to welcome you here. You're going to say something perhaps about your own experiences of this room and Reed Hall, but Katharina is also now a member of our faculty advisory board, and we're very lucky to have her. But more importantly, she's a very important legal thinker, and we're here to celebrate and discuss this book of hers that has just come out, The Code of Capital, How the Law Creates Wealth and Inequality, which I think is an extremely important work. She's the Edwin B. Professor of Comparative Law at the Columbia Law School. She directs something called the Center for Global Legal Transformation. She's been at the law school since 2001. And this is a book that, so far as I can tell, has been a good 10 years or more in the making, in the germinating, and you sense that as you read it. Academics have very strange aspirations, and one of the strange aspirations of many academics is to be thought to be the article of one classic article, the author of a classic article that will last for decades. Well, I think Katharina is the author of a classic article, which was her article on the legal theory of finance that came out in 2013. If you don't usually dip into the Journal of Comparative Economics, you might want to, because I think it's a really important intervention, but the alternative might be to read this book, which will give you the fundamentals of what she's talking about. Basically, the argument we're going to hear about is the argument that there's nothing natural about financial markets in particular. Financial markets are constructs, and they're constructs of a particular group of people who have not been much targeted by theorists of political economy, namely lawyers. And the whole book is an explication in a very persuasive detail of that, and I'm looking forward to hearing from you more about that. Katharina will talk for about 40 minutes, and then we're very fortunate to have Matthias Thiemann, who is a former PhD from Columbia University, from the Department of Sociology, where I think you were on his examining committee, but is now Assistant Professor of European Public Policy at Sciences Po, just down the road. So we hope that this will be the first of many meetings with you, Matthias, here at the Institute, and the author of a 2018 book called The Growth of Shadow Banking. So one of the other things I hope I will learn about this evening is what shadow banking is, because I'm not completely sure. But we will start with Katharina, and then you will respond, and then there should be time at the end for questions. Thank you very much.
So first of all, thank you so much for this very kind introduction, Mark, and thank you for the organizers of this event to put this all together. It's a great pleasure for me to be here. I was just telling Mark that in January of 2013, I actually taught in this very room a winter seminar, which took about a week, about my legal theory of finance that he just mentioned. I got some funding to bring together an interdisciplinary group of young scholars, basically graduate students, young assistant professors from Iceland to Turkey in economics, history, law, political science. I think we also had a sociologist. It was meant to be interdisciplinary. We basically were talking through the different aspects of the legal theory of finance, and it was really one of my greatest teaching experience because it was such a diverse group and they were so engaged. So I'm sort of have lots of great memories in this particular room. I'm also very grateful that we have the books here for you available if you want to buy them, or you can get them online. It's of course fun when you brood over a topic for such a long time and you write and write and rewrite and rewrite. I rewrote this book several times because I wanted to write something that is actually complicated and dry and abstract to an audience of non-lawyers. And some people still tell me it's just too abstract, and at some level law is abstract. I can't help it completely. I might have done even better, but that's sort of the ambition. I want to reach out to people to explain the world that we live in, because I think it's deeply coded in law, and without understanding the legal structures that create our global capitalist system, I don't think we can fully understand it, and much less can think about how to reform it. So that's basically the story here. You see the book in the back. It just came out at the end of May, so it's still fresh. And here's the basic story. I'm basically giving you, this is how academic works. I'm basically asking the question, well, what actually is capital? And how is capital made? And I'm basically saying capital is coded in law, and you can have ordinary assets, and then you can have capital assets. So a piece of land is just a piece of dirt. It's not a property right. It's not real estate, right? For a piece of land to become a property right, something else must happen. For a promise to receive future cash flows, it could just be a promise, right? But to make it enforceable, and maybe to have another asset to back it, to have a collateral, something else must happen. If you have an idea or you make a new invention, that's just your invention. Anybody else can invent it as well. But to have an intellectual property rights, you need a patent, right? And for intellectual property rights, nobody would dispute it. We know that they don't exist in nature, that you have to create a legal structure that recognizes something as an intellectual property right, as something that is patentable or deserves copyright protection. People, however, very often naturalize and reify land as property, and that's not what it is. And I hope to convince you of that this evening. So I'm basically saying for an ordinary asset to be flipped into a capital asset, it needs to have 4 attributes. Or the holder of these assets needs to be endowed with certain rights that are characterized by these attributes. And these are priority, durability, universality, and convertibility. So priority is all about ranking, right? I have better rights than you, so I can take it out, or I can exclude you from certain uses of the assets. As an owner, I can determine by and large, with some exceptions, who can use the asset and at what price, whether I want to sell it, whether I want to use it myself, etc. I have priority rights over everybody else. Now, that's great already. It puts you in a much, much better position than anybody else. But somebody could come along and take the asset away from you. For example, if you use your property right to put a mortgage on it to get a loan, the creditor might take the house away from you and the land on which it sits. So in order to really create wealth over time, which is what I mean by capital, it's basically generating private wealth, you need to give the asset and its holder durability. You have to create an incubator where wealth can grow over time. And durability basically means to extend these priorities in time through legal devices that allow you to protect your assets from certain groups of creditors, for example, to not put it on the auction block, even when you cannot pay your debt, as one example. These, both the priority, the ranking, and the extension in time, the durability, have to be enforceable against anybody, not just those who were at the bargaining table when we created these rights, because it really gives me much better protection. If just anybody comes along, wants to trespass on my land, I can call in the police and I can call in the courts to push them away. I might build a fence, but I don't even have to build a fence. I can basically invoke the public powers of coercion to have my property rights enforced. That's what I mean by universality. They're once recognized in law, they will be enforceable against anybody else. Erga omnes, the lawyers like to talk in Latin. And then last but not least, ideally I have the option to take my asset and flip it into a safer asset whenever its value is under threat. And that's particularly relevant for financial assets. So I might have a fancy financial asset, a securitized asset, or a derivative, and if the value decreases rapidly, I would like to lock in my past gains. So I want to be able to convert it into something that can keep its value. And the one financial asset that keeps its nominal value, not necessarily its real value, is legal tender, the cash that our central banks issue. Right, so you want to be able to convert it, and either you have access directly to the central bank, or you create a put option that is big enough that no central bank can refuse it. And of course, we have seen both of that in the financial crisis. So the building blocks really of my book are these. You have an asset and you want to flip it into a capital that is wealth-generating asset. You need certain attributes. And these attributes, let me just do this first. These attributes are conferred on these assets through different legal modules. And one of the things that occurred to me when I was doing my research for the legal theory of finance and wrote this paper back in 2013 or 2012, was that when we look at the complex financial system that we have, when you look at asset-backed securities, derivatives, all this fancy stuff, special purpose vehicles, we have all this financial jargon. When you unpack their legal structure, you find these elements. Exactly these elements are the modules of the code. Property law, collateral law, trust law, by which I mean the common law trust, corporate law, bankruptcy law, and then contract law, which can mimic or substitute for some of the others. And so when you think about this, what I'm doing in the book then, I'm basically saying, okay, let's look at different assets historically and comparatively and see how they have been coded as capital using these type of legal modules, right? So if you want to have sort of the 5-minute or 2-minute elevator speech, I'm basically saying in this book that give me any asset. Give me any idea, claim, object, and I can flip it into a capital that is wealth-generating asset by injecting the right legal DNA, think genetic code, into that asset, right? And the legal DNA are given by these modules or the elements of the code. Let me just go back one step. So why do I think that these legal elements are so important? What is law doing here? Why law? The key issue here is that you can endow these assets with rights that are enforceable if necessary using the coercive powers of the state. And that gives you power, that gives you reach, makes it durable, extended in space and time in a way that you can't do this contractually in principle. Now, one big caveat is, and that's something that we have to think about in the future, is through digital technology, I can do contractually, which something that before has been done mostly through the threat of coercion by the state. So there's a new dimension in which we can code our relations that can be done contractually and that raises important issues. But if I just to stick to the law for a moment and ignore the digital code, I think what is important to realize that in Western societies in particular, state power has been institutionalized in law and law enforcement institutions, law and courts and regulators. But they have been institutionalized in a particular way. It's not only through top-down regulation by the state, telling citizens what to do. So it's not just state-citizens relations. Neither is it just citizen-states, because in our rule of law-based constitutional democracies, we're also endowing citizens with rights against the state, right? Civil and political rights as negative rights against the state. But what is, I think, often overlooked, and which is crucial for the story I'm telling in the book, is that citizens can invoke law and the powers of the states to organize their life vis-a-vis other citizens or other individuals and entities, right? So it's this horizontal relationship in which you can nonetheless avail yourself of the powers, of the coercive powers of the state to organize these relationships. And I think we have to look at that, how power is used in this way. Very often we think about markets being spontaneous and natural and people just transact and bargain, but in truth it's that they do this not only in the shadow, but directly invoking elements of law that bring in state power. So just to come back briefly on the assets that I'm discussing in the book, this is land, firms, debt, and know-how. In my presentation today, I want to focus only on land and debt. I'm happy to come back to the other stories if you want to hear more about them. But I just want to also leave enough time to Matthias. And I think, you know, once you get the basic story, I think you can see how the other stories might unfold. And for each of these, we can invoke different modules of the Code of Capital to flip these simple assets into capital. Okay, so let me start by the story about land. So I start the chapter, which is chapter 2, by looking at a contemporary case, and it's a litigation that the Maya, indigenous people of Belize, brought against the Belize government. And they tried to do this already in the 1990s, and their case was not heard. So they confronted a complete denial of justice. They went then to the Inter-American Human Rights Commission, won their case there, which gave them enough publicity and to be able to go back to Belize and actually bring their case to the courts there, because the Belize courts are not bound by what the Inter-American Human Rights Commission says. So they brought it to the domestic courts, and they finally in 2007 won the case. And the case was about whether the Maya, who had practiced collective use rights over their lands over centuries, whether these collective use rights would be protected as property rights under the Constitution, so that the Belize government would be denied the right, which they had been exercising, assuming that right, to grant licenses to mining companies to exploit the resources of that land. So the Maya want to say it's our land. Now, at face value, this land was never titled and zoned and not registered as property. But of course, the question is only that land that is titled and zoned property, or could something else also be property? And in a really interesting decision, the Belize Supreme Court basically argued what property has to be defined, and as you may be aware of, is that in very few, if any, constitutions is there a clear definition of what property is. Property is assumed, right? So basically the power relations that are pre-constitutional are then conferred with constitutional status once we write these constitutions. So we have the property is there, we know what it is, but when it's not so clear, how do we define it? And there's nothing really in the Constitution that helps you other than general principles that the indigenous people should have commands over their own life, etc. Anyway, so the Supreme Court basically said, you know, looking at these rights for indigenous people, looking at our statute on property, we do decide now that these century-old collective use rights should be protected as property. That's in stark contrast with what happened a couple of centuries earlier when we look at the enclosure of land in the UK in the 16th and 17th century, right? There was also a battle between the commoners, like the Maya, if you like, and the landlords, who had used to share the land in common. They basically had certain temporal use rights. Sometimes the landlord had the right to close the fence and use it only for himself, but in general, the fence had to be open so that others could graze their cattle, etc. And then through the course of the 16th century, multiple legal battles ensued about who actually had the better right to the land. because the landlords had discovered that they could use the land more lucratively by grazing sheep and using the wool to sell it into textile, or growing cash crops which they could sell into the cities rather than just for their own sustenance. And so they started to build fences and grow hedges, and the commoners then broke the fences and broke the hedges. And so this went back and forth for a while, and then eventually they wound up in court, in the courts of equity, chancery courts in England. And so how do you decide who has the better right when you don't have a land registry, when you don't have property rights in land? And the arguments that the landlords made time and again is that they had priority. They were there first, seniority. They were there first, and they had just shared the land with the commoners out of their own discretion and had the right to take it back whenever they wanted. They did not win every single case, and many cases went back and forth. It took a century, but over the course of the 16th century, about 2/3 of English land was attributed to landlords as private property through legal battles in courts. So the big enclosure legislation came only later and considered mostly wasteland, and was only about a third, at most a third, of the land of England that was left at the time. So the point here is that the battle over the land took place both in the field and in the courtroom, but ultimately had to be won or lost in the courtroom when the landlords got their land. Now, when we take the same story about seniority and we have better rights to the settlers' colonies of the same legal system, right? English settlers go to North America, to Australia and New Zealand, and they do settle there. They bring their own law with them. Obviously, we all know who was first in these countries, right? So they flipped the argument. They basically said it's no longer about seniority, it's about improvement and discovery. So discovery is it's a sovereign claim to the territory, and improvement is we settle and we till the land with our hands and thereby create property rights. And that's, of course, John Locke. And John Locke sort of made this, it's a beautiful philosophical idea that, you own what you create with your own labor. But of course, he also was a British official in North America and had to find the legal argument, or the philosophical/legal argument, to justify the expropriation of Indians, which is what this was. Now, I want to just sort of draw your attention for a second to this picture, and then I will say more about this, because this is from Piketty's book in 2014, as you know, the Capital in the 21st Century. And I was just, when I read his book, it just like jumped at me that he shows us in these data, this for Britain and a similar one for the United States here, that the asset that was the most important source of wealth has changed over time. And the most dramatic change that we see here, I think, is the rural land, the big black bottom color here, is rural land in England was one of the most important sources of wealth until it collapsed basically around 1881 and then sort of declined. And other assets, of course, were important as well. So the other assets are housing, it's a light gray, and then other domestic capital is shares, bonds, mostly financial types of assets. But what sort of caught my attention here is that, first of all, that there are different assets at different points in time that are the most important source of wealth. And he explains this in his book simply by changes in demand and supply and changes in technology. And according to my reasoning, that can't be sufficient, because in order to keep an asset as a wealth-producing asset, it needs to have additional legal protection. And I will show you sort of, just by going back going to this story here, how changes in the law were really critical in stripping rural land of its status as the most important wealth-producing asset in Britain in the late 19th century. So I told you the story about land enclosure. Once the land was enclosed, the landlords also had the opportunity to mortgage their land, right? To raise financial capital, which they could plow into their commercial enterprises, and offer their land as a mortgage. And of course, when you do that, you also realize that the creditor, as I said earlier, can take the land away from you. And the landlords didn't really like that, of course. Once you have secured your property rights and you realize it's also risky to have them, you have to find new ways to protect your property against your creditors, right? First against the commoners, you have property rights, now against the creditors. How did they do this? They basically used what is called in this old English language an entail, which works very much like a trust. So I tell you how a trust works. It's basically to say, we are placing our assets behind a legal shield and give it to somebody who has the formal title to the asset, but doesn't have the right to derive economic benefits from it. So in the old days, trust emerged, most people would say, because of primogeniture rules in England. So if a father had two sons, by law, he would have to leave all the assets to the firstborn son. If he wanted to leave some assets to the secondborn son, he could not write a will because that wasn't legal. But what he did, and what lawyers designed for him, was to create a trust. So the father, it's me now, is basically the settler, the owner of the asset, basically transfers formal title to Matthias, who is my cousin, who holds only formal title but has no right to the economic value. And he holds these assets on for the benefit of Mark, who will receive the asset upon my death. Now, once I have transferred title to Matthias, my creditors don't have access to the asset because I don't no longer own it. I might still use it. It's still, nobody sees anything. We only have written up a trust deed, right? But I have the asset still in position, but I no longer have title to it. Matthias can manage it and has to manage it, has formal title, but no economic benefit, so his creditors can't access the asset. And Mark doesn't have the asset yet, which means that my personal creditors can't get it, his personal creditors can't get it, and his personal creditors can't get it either. That's what a trust does. That's why it's the most important vehicle for hiding wealth to this day. This is how rich people hide their wealth, and by and large, that's what the trusts do. And it was recognized in the courts. There was a predecessor, the use, which worked very similarly, which was challenged by a royal decree at some point. They said you can no longer use it, or you can use it only for certain things. And the lawyers, in their ingenuity, then sort of created something that was almost the same thing, and had it vindicated by the courts. That's the trust, and the trust is with us to this day. This is just another footnote that I should highlight here. I mentioned this when we talked earlier. When I talk to practitioners in New York, they basically tell you that they can use these modules of the code, as I call them. That's not what they call them, but they can use the modules of the Code of Capital to mute or leave ineffective almost every public regulation. It just takes a while, some ingenuity to do this, but you can get around it by creating new types of things. So that's the English story. What they did, the landed families, once they realized that they could lose their land to creditors, what they did is that they, through the estate, or the family estate, behind a legal veil like a trust, the father, the family head that was managing it, was not the owner, but only the life tenant. He held this only temporarily for future generations, with the effect that his creditors couldn't get to all the assets. They could only seize a maximum 50% of the assets, even if they had a mortgage, and not the family mansion. And as you can sort of imagine, this is not the most efficient system. You have creditors who give money, but they can't recover what they gave over time. And at some point, the whole system collapsed, and that was in the 1870s. The owners stopped investing in the assets because they had to protect the assets for future generations, by and large, in the way they had been. And so they lost the competition then with North American products, especially after the corn laws were repealed, and sort of the products flooded in from North America, and that left Britain in the 1870s in a major downturn. And just to go back to this slide here, complete collapse of agriculture. And then in 1881, the first time that the landowners no longer had majority in the House of Commons, they enacted two laws, the Settlement Act and the Land Recovery Act, and according to these laws, the life tenant was now treated as an owner, and you could completely recover land. And in the next 20 years, about 20% of all English land changed hands, and one of the most massive reallocations of property rights right here. So that's, I think, what went on here. Land stopped being an important source of wealth because we basically took away durability. We took away the ability of creditors to take it away from the owner. We stripped it of its protection against bankruptcy that it had, and thereby basically made it just an ordinary asset. Yes, property, but you can lose it, right? And that was basically the demise of land. Ever since, of course, we have learned how to throw financial assets into trusts and protect it in very similar ways, and actually much more flexibly, and that's why we can create new sources of wealth. So let me just give you two more examples about the land before I move on, because in England we had the struggle over the landed elites trying to protect basically a feudalistic type of ownership regime, which they had secured through the land enclosures, through legal mechanisms until well into the 19th century. At the end of the 19th century, The Economist wrote in the 1860s that the system was totally absurd for an industrializing country, but that's what it was. But compare this with what British lawyers and legislatures did in the colonies. So in colonial America, they basically implemented the reforms that they implemented in Britain in 1881, 150 years earlier. So they enacted in 1732 the Debt Recovery Act for North America, which basically said we will treat land as chattel. We will treat real estate as if it was personal or movable property against which you can enforce all the rights that you have, no restrictions, which basically busted some of the big real estates in the South, which led to the first slave auctions because slaves were collateral and they could be sold as well. So 150 years earlier, we had a different legal approach. And of course, in this scenario, the English were on the side of the creditors, not the owners. And so they knew exactly what you need to do to strengthen creditors' rights. One more example, if you go to India in the 19th century, where you have also the Brits went in, they looked at land markets, they looked at credit markets, they found that most creditors had monopoly rights. They basically charged huge usurious interest rates to peasants, but they also created long-term relations with them. And the Brits, as colonizers went in, said this is totally inefficient. If we create competitive creditors markets, then the cost of credit will decline and all the peasants can get credit and it will be fine. But to do so, we basically create courts and we make the peasants responsible with their land and with their houses for the debts they take on. And so what happened, of course, is that they introduced the reforms. They were enormously successful. They brought in many creditors, mostly from the outside. They did not create a long-term relationship with local peasants, but they reduced the cost of debt finance. Debt finance exploded. And then, lo and behold, you get your famous exogenous shock, right? You have the collapse of cotton markets in international markets, and the peasants can't repay, so the courts evict. And they evict so effectively that you get land masses of landless peasants who then eventually stage a mutiny, as the British call it, against the colonial government. So here you have a political economy setting where, again, the Brits go in and do what like a economic textbook property regime would look like. You empower the creditors. When you put it in place, you're disrupting, of course, local relations and you're even threatening colonial rule. So this is just by way of example that we can actually code these rights, the relationship between creditors and owners, in various different ways. And so the code is just not entirely abstract, of course. It's embedded in a political economy, which we have to understand. But I think we can understand also the political economy by looking at the code and who is empowered and how these different agents are empowered. Mark, let me just hear about the time management since we started later. I didn't want to go into the firms, but I want to say a little bit about that, and then I will give Matthias some time. So I wanted to now basically jump to another asset, which, if you remember the graph, of course, is also important. So rural land declines. Then, of course, we have financial assets in general, and we have housing. And housing, of course, is also largely debt financed. So I thought I'll tell you the story in chapter 4 about minting debt and how that works. And it's basically a story about securitization of mortgages in the United States and the legal structures that we use. And I'll skip sort of the historical stuff. There's always, lots of stuff where you can look at different financial assets and how they have been coded. But let me show you this. So here on this graph, what you see, is on the left-hand side, you see the little houses in California and the little homeowners. They all take out loans to buy homes, and they mortgage their houses. So they basically give the bank a right to enforce against the house, to take the house away from them if they can't pay their loan, right? And NC is New Century. It's one of the mortgage originators, a very aggressive mortgage originator that operated in California that actually went bankrupt already in the spring of 2007. So the practice I'm describing here is not unique to this particular structure, but I'm just taking one structure to show you how it works. So New Century basically goes out and sells loans, or gives loans to homeowners, takes the mortgage, and then assembles thousands of them, puts them all together and does a wholesale transaction with a big bank like Citi. And Citi has multiple separate legal entities, subsidiaries of different kinds. One of them is basically an entity that acquires from New Century and from other originators, but here from New Century, thousands of mortgages worth millions and millions of dollars. And then doesn't keep them on their own balance sheet, but creates a trust. That's the Century. We call this a special purpose vehicle in financial jargon, but in legal terms, it's a trust. It's the same trust that we just created with me as a settler and Matthias as a trustee and Mark as the beneficiary. So here, one of the Citi affiliates will be the settler, and they will hire another financial intermediary, Bank of America or JP Morgan Chase or whatever. They basically just switch roles for one another. One is the settler, one is the trustee, and the beneficiaries now are not the second-born sons, but the investors. So we use the trust as an investment vehicle. The assets in the trust are all these loans backed by mortgages that NC had originated from the homeowners in California. Now they issue certificates to investors, and these certificates promise not only an equal share in the cash flow on these mortgages, but they actually promise fixed returns. So they typically give everybody a particular fixed returns, and they do something else. That's what the private sector has invented. They use contract law, to create different, they call this tranches, like to trancher. So they tranched the cash flows in the assets to allow some investors to buy senior tranches, which were secure, which meant they always were the first ones to get cash flow when it came in from the mortgage payments. And they would be the last ones to bite the bullets and suffer losses if no payments came in. Then you have medium sort of mezzanine tranches of different sorts, and then you have junior tranches, which means you are always the last one to get anything that comes in, always the first to bite the bullet. There were investors who liked that because they got higher yields for these investments, but they also had the risk. If they got stuck with this, this was a problem. So the senior tranches in these type of structures were typically sold to, let's say, Fannie Mae, Freddie Mac, some of the government-sponsored mortgage companies that had started the securitization in the 1970s, but once the private sector had taken over, was basically a major buyer of senior tranches. And then the next, you got sort of some of the sovereign wealth funds, like the China Investment Corporation, you got Bayerische Landesbank, German state-owned banks, and you got, of course, BNP Paribas from France that went into this market only in 2005 and was hit by major losses just shortly thereafter, and many other international investors. So I put these little flags here. So Citi is New York, and then Fannie Mae is, of course, the United States, China, etc., to give you a sense that you can play this game globally, right? So now there's one problem with securitization. The investors, buy these different things. It's easy to buy senior, to sell senior to investors. It's easy to sell junior. It's easy sort of to, be just above junior and just below senior. There's always this lower mezzanine tranches that are difficult to sell. Nobody wants them because they're not safe, and neither are they risky enough to really generate the yields that you want. But if you can't sell all the tranches, you can't put this entire securitization structure into place. You don't want to get stuck always with the mezzanine tranches as the sponsor. So what the financial industry did is just invented its own buyers. So this is what we call a collateralized debt obligation. You just create another legal entity, which is this another thing, it's called Claros, in the Cayman Island, this time, so of course, tax benefits. You set up a corporate entity that promises investors that they will buy the lower mezzanine tranches from a gazillion different securitization structures. And because the assets are so diverse, they come from so many different securitization structures, so many different homeowners, that it's very unlikely that they will all fail at the same time, which is the argument they use to go to rating agencies and says, well, some of the cash flow in these CDO structures should be AAA because the likelihood that the senior tranches will suffer a loss is just very, very low. So they take basically lower mezzanine assets by lumping them all together through the magic of scale and probability calculus. So, well, some of the cash flows will be safe enough to get AAA, and then they sell it again. And if you then again get stuck on the lower mezzanine, you just do CDO squared and cubed, and they all existed. You just create another entity, you promise investors certain cash flows, the investors buy, you tranche the cash flows in a certain way, and you get rating agencies to buy into that. Now, what I just want to point out is my modules of the Code of Capital. I said it's property, it's collateral, it's trust, it's corporate, it's bankruptcy, and it is a contract. So homeowners, property rights, right? Homeowners, property rights. City is a huge corporation. The security structure is a trust, right? Most of the investors, of course, are corporations in their own right. Then you have CDOs, which are corporations, again, can also be trust. And so you have basically all the elements in place. Let me say one more thing here. The instruments that were created, what the lawyers like to call just structured finance, others talk about shadow banking. It's basically an attempt to make debt finance available outside the institutions of traditional banks, right? So we're using asset-backed securitization to disintermediate lending relationships. It's basically you have a buyer of mortgages, you get the collateral, you sell it to a different entity, you get different rights that you allocate to different investors, you have different cash flow coming in from somewhere else. It's not all in-house in one single bank, but you have basically created a chain of these things. And this chain is sustained by also selling these assets globally and raising capital through that. One important aspect that I just want to mention here is that we have also created contractual structures for selling these assets and the derivatives in particular globally. And these global structures were created by an association which has all the major financial intermediaries and the biggest law firm in the world designing a master contract for them. Am I losing my picture now again? No, here it is. Okay. So these are the two case studies I want to present to you. One is land, the other is debt. And I want to raise a few more issues, and I will just skip through this, but I want to talk about this. I made the argument that capital is coded in law, and that the critical elements are property rights, collateral, debt, trust, corporate and bankruptcy law, and of course contracts. These are domestic legal elements. These elements or modules don't really exist at a global setting. And so you could basically come back to me and say, well, we live in a global financial system, a global capitalist system. How can we have a global capitalist system without a global state and global law if your argument is true, right? If capital is coded in law, then you need that for a global system. And my response to that is, well, in theory, we could have a single domestic legal system sustain a global system as long as all other sovereigns respect, recognize, and enforce the legal structures that are created under the first legal system, right? And we don't have a system with only one domestic legal system doing that, but we have two. We basically have the law of England and the laws of the state of New York that are sustaining most of our global capitalist system. How does this work? It works mostly through a set of rules that we call in law conflict of law rules, which are domestic law, that tell you which law should be applicable to a particular fact pattern when more than one is in place. So if you go and you go to Germany on vacation tomorrow and you're being hit by a car that is driven by an Italian, and then you're coming back to France, the question is, when you sued, under what law do you sue? French law, German law, Italian law, right? And so these rules tell the judge that for a tort action like a car accident, it's typically the law of the place where the accident happened and perhaps where the injury was sustained. That was a matter of French law to decide. For corporate law, it's to say either you can choose where you want to be incorporated anywhere. As long as you follow these rules, we will recognize you as a corporation. Or it could be the German and partly the French way, which although has been undermined by the European Court of Justice, to say you've got to be incorporated where you have your headquarters and major operations, because we want to control you then. So a different conflict of law rules. most countries over the last 20, 30 years, partly under pressure of case law, for example, by the European Court of Justice, have given private parties ever greater autonomy to pick and choose the law that they wish to govern their transaction. So for contract law, we've always done that since the 19th century. For property, the basic rule was the law governance in the location where the property asset is located. So if your house in France, it's French law. If you have an object that happens to be in France, it's going to be French law. There's a famous case where a famous actor left his underpants in a hotel room, and sort of when he was sued for alimony, the fact that there was property found in that room that belonged to him sort of suggested which law would apply. Okay, so the problem, though, with financial assets is that financial assets do not have a location. Right? They have no location, so they don't really follow into the territorial principle. So the lawyers from the biggest firms came together in The Hague and drafted a big convention where they basically announced this new principle that the place where the issuer is registered as a corporation can be the place under which the assets are issued for property rights purposes, or it could be a contract between the account manager and the account holder, which basically in effect means that now we have the possibility to select our own property rights simply by putting the entity that issues the assets in a particular jurisdiction, let's say into London rather than into Frankfurt, or that we have a contract that says which law shall apply, which basically means we're curtailing the state's own sovereignty, legal sovereignty to govern property rights because you give it the option to others. So that's basically, this is again an arcane set of legal rules. Few people know about them, but they're absolutely important to understand how it is that we actually have two domestic legal systems that control most of the globally traded financial assets, and I think these are England and the state of New York. So let me just say a final word just about who's done it. So I'm basically arguing this is all law, and so the question says who really does that? And I'm saying the masters of the code are the private attorneys, right? They do it. The courts are actually increasingly being sidelines, but the attorneys, they have the skills to write these contracts, and you can go back, and this happened already in England in the 18th and 19th century. There's a famous quote by Lord Campbell that I have in the book where he tells his fellow lords in the House of Lords in the late 19th century, I tried again to reform English real estate law. That was before the crisis I talked about earlier. And he says it was impossible to pass this bill, not so much because the landowners didn't know that we needed reform. They realized we need reform. But there is an estate in this realm that is more powerful than you and I, he said, and that is the country solicitor. So the country solicitor who knows how to convey land, how to understand ownership structure in this difficult, complex, opaque mess of entails and trusts and who owns something we just didn't really know anymore, they had a monopoly over that. And similarly, the lawyers today know how to do structured finance, how to create wealth by using the law in a very imaginative way. And it's particularly, I think, the lawyers in common law countries, in part because for historical reasons, independent private legal professions emerged here much earlier and have always been more powerful. There's also the organization of courts and how people are recruited to judgeships is fundamentally different from civil law countries. In the common law countries, judges are recruited from the bar, from the practitioners world, whereas in civil law countries, judges become judges right after law school, or have special training, like in France, to become judges rather than prosecutors, rather than going into private practice. So in the common law system, so the private practice always had a special role. And here we have the global financial centers, but we talk a lot about the global financial centers. Saskia Sassen has written about this years ago. But what people talk less about is that the top 100 global law firms are also sitting in London and New York. And I just gave you the top 20, all English names, all either American or English. And when you go down the list to 100, you have the same thing. So that's basically the story. Let me just raise one more issue, then I really will cede the floor. The problem that we have, so we can create enormous amounts of wealth. What's wrong with that, right? If you can avail yourself of the coercive powers of the state to create wealth, why not do this? We could create something out of nothing, as Thorstein Veblen has said this many decades ago. The fundamental problem, of course, is that it's done in a way where, first of all, it's opaque, not really clear to many. It's done today in a global setting by lawyers and their clients being able to pick and choose the law from different jurisdictions around the globe to advance the interests of their clients, without having to adhere to the norms that a particular society creates for itself. So fundamentally, I think we are in a situation where we have to ask ourselves whether we still have the ability to govern ourselves, because in democracies we govern ourselves through law. And the greater the scope is for some to opt out of the legal system, opt into others by their choice, the lesser our ability is to govern ourselves. And so I think that is really the challenge that we're facing. I have some suggestions in the book about how we can do about this, but I don't want to take more time right now. I'm happy to come back to that in the Q&A.
Thank you so much.
Can you hear me? No?
There's a button that you can press that I showed you before.
Thank you very much. So, thank you very much for inviting me and having the capacity to discuss this book. I'm thrilled. I think we're all very lucky here today to discuss this book, which I think is very important on many different levels. I think one is it helps us to understand how it is that we are so screwed up, if I may, in how it is that we're living in such a screwed up world. And at the same time, it is speaking to much deeper social science theoretical issues that I'll try to touch shortly upon, because I only have 10 minutes, so I'll make it short. But I think so, and let me start by saying the coup, the amazing coup that we have here is somebody taking an instance, which is the global financial crisis, and finding from it the abstract forms that underlie it, and making the bold, but I think justified claim to say this is what has been going on for the last 500 years. And that is courageous, but I think it's definitely very, very fertile, and I think it will generate a lot of work. So this, I think, I've brought this book, and you can guess what it is. It's not a law book; it's actually Marx Capital, and I think that this book definitely stands in the line of many books that that person started, and I'll try to draw out a little bit where the continuities and improvements are to Marx, but also where a little bit of the questions still are. But before I do that, I want to stay in the contemporary world and just speak about Piketty. And I think what Katharina does is she just says, well, if you want to tax, dear Monsieur Piketty, it's a great idea, but you first have to get a hold of capital. You have to first understand how capital is capital, which is it has all these protections from the reach of the state. And these are all these 4 modules that you've seen that are applied to it. And the crucial question is, for us today, is actually how do you break this? How do you break through this? And here I want to be, because I only have 10 minutes, I'll start with the first question. Why not be Rabiat and just forbid the trust? But you just take it, and but I want to, but that's just a question that I have. But I think what it also does, so it speaks to Piketty, and it's maybe putting almost too much blame on the masters of the code, which are the lawyers, for all they're doing, because it always takes 2 to tango. So I want to know, what about the states? Why are the states playing along in this game? Is it really that these soft-spoken, well-mannered people in New York that sit on the 20th floor and look like they could do no harm to nobody, at least when I met them, they look like that, that they could do so much harm? And what about the state? But I think before I do that, I want just very shortly do a little bit social theory, or say how it speaks to social theory. I think the first is Max Weber has come up with this riddle when he said, look, capitalists need predictability. Why in the world is the common law so much better, case law so much better than code law? because code law is predictability. And I think Katharina has given an answer to that. Because what she has said is basically, it is because the mechanisms of the coding of capital in common law allow predictability for the owners of capital, and only for them. And possibly, and this is in an as-if legality relationship, legal as long as proven otherwise, which is exactly the interesting dynamic here that I think we should talk about. But this is something that is a very interesting answer. The second one is, when I read this Code of Capital, when I opened it, I didn't open it yet, I thought, great, Marx and Luhmann in one book. Like, the code is something that Luhmann speaks about a lot, and capital is something. And so let me just tell you a little bit. I think capital is a social relation, Marx says. And while we read Pistor, we could say, yes, it is the social relation, and it's brought about in the realm of law. But the law is not a representation of anything that is out there, but it is actually the form of communication within which capital exists, and the only way within which capital exists and is formed. And that might help us to overcome a certain lack of attention to the state and the practice of the law in Marx, or in Marxist scholarship. So in other words, the granting of property rights and their defense and the use of contract law, collateral law, and trust and so on to achieve that effect, to defend these assets, is what capital is. And in a sense, for me, that is just 21st century Marxism, or what 21st century Marxism should be. But we can discuss about that. For me, there is actually, when you read the theory of primitive accumulation, the chapter by Marx, a lot of what Katharina has spoken about is already there. When he speaks about the fact that feudal property rights, which was the fact that the lord had a legal obligation to take care of its tenants, was replaced with the modern property right, which is the inalienable right to own something and kick everybody off the land and not care what's going to happen to them, which is what underlies the enclosures, is what Marx describes. But what Katharina gives us then is she says, well, but once they achieve that, they turn around and they use every means of feudal residue that is still there to protect what they have now gained. And that's just fantastic, because if you're just a modernist, you think, well, they just got rid of all the feudal way of seeing the world. Well, when you look through it to Katharina's eyes, you say, no, wait, it's going like that. First you get rid and you appropriate stuff, and then you draw on anything that is there, like the trust, to make sure that you can keep it. So it's a very versatile and flexible use of the law that we can really see there. And so I don't have enough time, but I'll just mention shortly, and I would like to ask you that. David Harvey has written about the theory of accumulation by dispossession. And he has essentially used Rosa Luxemburg's concept. And when I read your chapters on coding property rights, coding nature, coding all of it, I was like, yep, that sounds like the theory of accumulation by dispossession. You just take something from everybody, because nobody owns it, and make it yours. So isn't there, because you put the Marxists aside, you have these two guys, the rational choice guys and the Marxists, and you're like, nah, let's go my way, which is fine. But I was wondering a little bit, like, isn't that evident ally almost? The second one is Luhmann, and of course law is a communication system, so you have this dynamic. Law just goes on, and people try to figure out what is legal and what is not. And if you notice literature a little bit, there is Teubner and Fischer-Lescano that speak about systems collisions, and they speak about lex mercatoria as the private law which was there when and co-evolved with state law. And I think especially the relationship between splintered authority of different sovereigns and the private agent, that is what you pick up, and what you could maybe even make a bit stronger in the book, because it seems to be this multiplicity, this capacity to either go to that court or to that court, or to the equity, the law and equity, and so on. So playing off these different agents, these different ways or places where law is made, has empowered these private agents that you're studying. And I think that's fascinating, but we need to maybe speak a little bit more about this. Now, there are these liminal places where public and private meet in your book, where, for example, we learned about safe harbor and it was extended. So I think one reason also, as I think hopefully you agree, was also to make government debt more attractive. And so there was an interest of state agents to expose that. But then I think in the book I learned so much about the citizens and how it is structured and how it almost has escaped any reach and any control. But I want to know more about when public law and private law interact. And I've told this to you earlier, I think this is in a sense almost a very American book, although it's written by a German scholar, and I'll come with a very heavy-handed German philosopher and state theorist, which is Carl Schmitt, and the capacity of the state to pronounce the state of exception. And so the question is, well, does the state not have the capacity to annul this game? Or when can it annul this game? And in a sense, it's almost at the end of it, and I'll end with that because I understood that I don't have so much time. But at the end of the book, you give us these two choices. You say either the radical market of Posner and Weil, which I think in European discourse will just be described as maniacs, but in American discourse, of course, are very reputable scholars. So I hope I did not offend anybody who suggests let's just dissolve jurisdiction and law and just move to the complete market. And you can correct me if I'm speaking of that wrongly. And then there's this other person, philosopher, who speaks of the capacity of people to deliberate and to get together and to maybe change the way that they restructure their world, the legal world. I think that's very good. At the same time, when I read this, I have this question about, well, in Hegelian philosophy of rights, right? If you read this, he says, rights and duties always come together. And without duties, there are no rights. Without rights, there are no duties. Like they are dialectic unity, right? And so in German law, we say in the Constitution, or in what could be, you know what I mean, the Grundgesetz, we say capital has social obligations. Or Kapitalverpflichtet, yeah, please translate it properly, I don't know how to translate that. But this idea that capital has not only rights, but also duties. And the question of how one could insert these duties into what seems to be an uncontrollable system of law that just wriggles itself free from any legal constraints that are imposed upon it. I would like to hear much more about that, so I'm looking forward to your answers. Thank you.
Thank you so much. So it would be nice to have some questions, but I'm sure you want to.
Maybe just a brief response, but I would really like to hear from you. So this is wonderful. Thank you so much, Matthias. Let me just sort of hit on this point. Aren't you really a Marxist? And yeah, maybe I'm a closeted Marxist. I think I really wanted to focus on these mechanisms, and I've talked to some neo-Marxists along the way, and they always wanted to know about the class structure. And I think what I wanted to look at is sort of the malleability of the system, which doesn't require really class identity, and where actually also new agents can come up and code their new capital if they get access to this legal coding device, right? So when we transform from land to debt to other financial assets, some make the move soon enough so that they can participate in this new way. But you don't necessarily have to be, still a member of a particular elite, but you can become a new elite by a particular coding strategy. So I wanted to extract myself from the need of saying it's always a social relationship between labor and capital, but saying it's about these mechanisms that I want to focus on. I think that's the major reason. I agree with you with this splintered authority. One of the most important devices, or powerful devices for capital to be so powerful, is to actually move around and pick and choose the law they like. I call them like roving capital, and because they can basically run around and extract resources by getting into the legal system of a particular jurisdiction and using it. So this is really important, and I could say more. Just about the end, I think this maybe both were a little bit of a straw man looking at Posner and Wiley and Menke on the other side. But I think what I found intriguing in both arguments, both relatively recent publications that say we want to get rid of property rights because they do all these bad things, so we just allow completely the market. Anybody who can bid more for your house, you have to leave your house, right? Of course, ignoring the fact how you would enforce that. So you would need a massive state apparatus to do that. So that I found funny. But Menke also basically saying our subjective rights ideas are embedded in our constitutional frameworks, and they will always reproduce capital in a particular way. And therefore, we have to change this and do something like you have only temporal rights to achieve something with your subjective rights. And I just didn't see how this could be operationalized on either side. So I'm basically taking, therefore, a more pragmatic middle ground and taking my law and say, well, how could we change the legal rules? Final point, couldn't we just prohibit the trust? Well, I think it was Richard, some English king tried to prohibit the use and then came about the trust. The point is here that it's not legislated whether a trust is legal or not. The courts of equity recognize, this is your splintered authority, recognize the trust now as a legal vehicle. What has actually happened in recent years is that the legislatures were pushed by the financial industry to change trust law. Somebody, an Israeli lawyer, has written a great paper which is called The Stripping of the Trust, where actually the legislature has taken away most of the constraints and obligations and fiduciary roles that trustees have played in the past to make it an even easier vehicle for hiding and protecting wealth. So the interesting thing is when you come back to the state, and we can have a longer conversation about that maybe over dinner, that the state very often in the form of legislature sides on the side of capital and offers legal vehicles and even changes old legal vehicles in such a way that it benefits a particular group. So I think that's certainly what has happened over the last couple of decades, that the courts are pushed aside because they could sometimes do something wacky and crazy, but the legislatures you can lobby to do what you want. So, sorry, it was too long, but let's just take some changes.
So let's take any questions. If people would like to ask a question and identify themselves as, please, yes.
If you want to use the other one.
Sure.
Hello, thank you for this very interesting presentation. I was wondering in this...
Can you identify yourself?
Sorry, I forgot. I'm Yaiza Cabedo, and I'm doing a PhD on financial law, and I'm also working for the European regulator. It's called the European Securitization Market Authority. I enjoyed very much your presentation. And I wanted to ask you, in this wave of persuasion of financial industry towards the governments, the states, and the European Union or big financial hubs, which role do you think that the too big to fail has played? Because I understand that you said that this started happening 2 decades ago, and this is the same moment where the entities became too big to fail. I would like to know your views on that. And the second point, very quick, would you agree that the financial crisis of 2008-2007 was not only a financial crisis, but also a crisis of regulation and law? Thank you.
Okay.
Why not?
Okay, thanks. Great question. So too big to fail. It's a colloquial term that basically says some financial intermediaries are deemed by central banks or treasury or legislature as too risky to allow them to go under. And I think what is basically happening here in my terms is that we also protect them from bankruptcy, right? So we basically give them more durability than they would otherwise had. In theory, the creditors should be able to seize the assets and bring a debtor that doesn't pay his debt into bankruptcy. So we used to protect the landed elites by allowing them to entail their land, right? Then we have created some specific legal protections for some group of assets holders. So, for example, derivatives, CDOs, CDSs, repos, all that stuff. We have created in our bankruptcy code safe harbors, which allow the counterparties to derivatives transactions to be exempted from certain critical bankruptcy rules by which everybody else has to play. And it basically means that they can net out their assets and walk away and thereby basically protect themselves. So they are also exempted from certain bankruptcy rules. And in a way, too big to fail is de facto, you will be ad hoc exempted from bankruptcy rules because we will bail you out rather than allowing you to go through bankruptcy because we fear the consequences. And with Lehman Brothers, we of course have seen that. So in that sense, I think, this also of course means that in thinking about the next crisis and how financial intermediaries can position themselves strategically, if they know they could be too big to fail, then you just have to become very big and very interconnected so that the government will not allow you to fail. So there's a strategic game going on here, I think. So in the 2008 crisis was, of course, I wrote the legal theory of finance after the crisis, and we used the crisis as a prism to understand why existing theories didn't explain what really happened. And then basically we came up and was a collective undertaking with an interdisciplinary group of researchers to say actually the key building blocks are here, these private law elements, and of course the failure of regulation to realize how far they have been used and sometimes even supporting the creation of these private regulations. So what has emerged in the years up to the 2008 crisis was this massive shadow banking system. That's Matthias's expertise, but it's basically outside the banking structures, market-based credit systems with some of the elements I have described here. And the regulators were never really able to respond to them because their particular regulatory tasks, of course, are also circumscribed in a certain way. They can't even, and the assets and intermediaries are created so that the regulators cannot reach them. That's basically a dance that we're dancing all the time, but we can also push it then to levels that when they crash are really harmful for everybody else. So it was clearly a huge success story on the one hand. People became enormously rich. And of course, but the same mechanisms that made people rich also brought the financial system to its knees from which it had to be bailed out by the state.
I'm going to usurp my position and ask a question myself. And the question is about incomprehensibility, actually. And I was thinking as you were explaining, and particularly the unbelievably complex financial instruments, how difficult it is to understand what the hell is going on. And then I was thinking about what Matthias said about communication. It seems to me that there's a story that is 500 years old, and it's visible when you talk about land in particular, and about the role of the law in protecting in creating and protecting capital. And then there's a qualitatively different story that's only about 20 or 30 years old. And that is a story about financialization in particular, and about global financialization, in fact. The first story takes place in a world that we're familiar with from Marx, which is a world of political struggle. I mean, class fights class in one way or another. On the contrary, the big question that Matthias asked in the story of the last 20 or 30 years is, why isn't there more fighting? Why aren't states pushing back? States as representatives of some version of the public good. Why is there no pushing back by the state? Never mind classes. Let's forget about classes for a moment. But why isn't anybody pushing back? And it seems to me that part of the answer why they're not pushing back is nobody understands what's going on. Because we listen to your very lucid explanation, and it's not easy, with the best will in the world, to follow the nature of these mechanisms. The complexity, the incomprehensibility of them is part of their power. So we live in a world in which, in fact, technical incomprehensibility has a very precise function. And I wondered about your thoughts about that.
No, I think you're right, of course. I mean, I'm making this claim that the same institutions have been with us for 500 years, and that's true at some level, but of course the way they are being applied now and in what sort of complexity, that is really different. And I think you're right, this also emerged in the last couple of decades. I mean, one thing is that, everybody enormously benefited from this for quite some time, right? So you fight inflation in the 1970s, and how do you get your economies to grow? Through a credit boom, right? And the private sector is happily providing exploiting that. And it's doing that in such a fashion that we talk in the years leading up to the financial crisis as sort of this new area of moderation. Everybody seemed to believe that something phenomenal has happened because somehow we can grow like crazy without having the typical risks associated with it. That would be like a bank blows up every couple of years or so. But something so completely different has happened. Of course, then we have also this long period of very low interest rates, and the financial sector was trying to find yields elsewhere. So there are multiple factors that come together. And of course, and I think the lawyers play really an important role here because they exploit the new opportunities that the removal of capital controls, other entry barriers to different legal systems have enabled them to basically create these new types of assets. And yes, they're very difficult to understand. So most of them are 300 pages long. They have very different sections. You have to know what you're looking for when you really want to understand them, and that's something what lawyers learn. But it's incomprehensible to almost anybody else, and in part, of course, also by design. It's like the opaqueness that keeps sort of the profession in the game. But even for the professionals, so I've talked a lot to practitioners, and I'm not always sure whether I should believe them, but they basically say also nobody expected the financial crisis. However, I bring practitioners to my classes, and usually I ask them, to the delight of my students every time when they come here, when did you understand that this game could not go on forever? And my sense is that actually the lawyers got it earlier than the economists, because they basically say, when we were churning out like 50 of deals of that kind every week, right? And we do this, and the younger associates basically say, I'm not sure really what we were doing with like just reading all these documents, and they had no idea what the systemic effects could be, but when it's so much, they realize it couldn't go on. But the problem with the lawyers is that they are basically, they learn to focus on minute details, on this particular structure, and it has to be all consistent with one another. They're not trained to think systemically, and so they don't even take into consideration what the systemic effects are. So we have this funny game where those who think systemically know nothing about the law and the complexity it creates. I talked to central bankers and said, can I get the contracts you just bought these toxic assets, I want to have the contracts. Go and talk to a lawyer. They don't have the contracts. They're buying these assets on some representation. They have digital entries so that they know what they have, but they don't know what they have because they don't know what the contracts are, and they have never read them. So that's this strange, ungovernable world that we live in. Why didn't states push back? No, I think they sometimes push back. They push back after the dot-com crash. They push back eventually after Dodd-Frank. But I think also states just love the lubrication of the financial systems and lived off that because they didn't have to provide so much for themselves. They just put the entire country, especially the United States, on credit or debt dependence.
Hello, I'm Roger. I'm from Brazil. I'm taking a master exchange program here at Cienspol. I think you already started talking about that, but there was this point on your presentation about legal education and LLM programs, and you said now that probably lawyers are not trained to think systemically and understand the risks of what they're doing. I'd like you to expand a little bit about that. What should legal education look like for the future if we want, like, for this kind of crisis or this kind of problems that we have to not happen again? Like that.
Well, I'm a legal educator. I teach at Columbia Law School, which is one of the major feeding schools for Wall Street. I teach corporate law. So I'm doing all of the above. I'm also teaching a seminar on law and finance in theory and practice, which I co-teach with practitioners. So I do ask myself that question all the time. And frankly, I do bring the practitioners in to learn from them, to see what they're doing. And at the same time, I'm trying to train my students to think more critically, at least as long as they're in the law school, right? So I give them the legal theory of finance. They get all this prep work, and then they're being exposed to the lawyers, and they question them, and they take them to task as well. That's just, just an anecdote. Of course, more generally, I think, lawyering is an enormously powerful task, and it can be used for different purposes. We've seen in the civil rights movement how lawyers have used their legal tools to achieve social justice, right? I had Menaka Guruswamy and her partner Arundhati at Columbia Law School for the last 2 years, and they basically won the case in India last year about the LGBT movement. That was just phenomenal lawyering that they did as well, and that all can be done as well. We've had great people on our faculty who won the sort of the Brown versus Board of Education case. So lawyering is powerful. Has always been quite powerful. And what has happened over the last 30, 40 years is that the law school students have gone increasingly into coding capital. They don't call it that. This has a lot to do, of course, with the lucrativeness of the business. But of course, we also at a law school have made then decisions to increase student fees and increase salaries of faculty. I'm in that as well. So that we are all sort of in a game right now where basically somebody who goes to Columbia Law School has to pay $100,000 per year in living expenses and fees to get a law degree, and that times 3. So once you have $300,000 in debt, you don't have a choice. You go into these firms, right? And so we are thinking about, and we're doing more. We've always done practices where if you commit to public policy and social work, that is, you earn less than $65,000 for 5 years, we forgive your student fees entirely. So we do exposed, and we're doing more than that. We also get more competitive pressure. But I think there's something much more fundamental. With a fee structure like this, the way that lawyers are trained in the United States, with the amount of money it costs to become that, we just leave too few choices to lawyers to use their skills for other purposes. And I think we talk about this. We have a very liberal faculty. Lots of people have different ideas, and yet the truth is that 90% of our students end up in the big firms.
Thank you very. Yes, Matthias, please.
In your book, you tell this funny joke about these 2 Irish guys who ask, "How do I get to Dublin?" and the guy answers, "Not from here." And so maybe answering to the student is, I think, not from here. I don't think there is an answer to the problem that you're raising and that Katharina is discussing, as long as you stay within the system. And there was this one thing that I wanted to bring up from Marx, which is, there has been a change from feudal property rights towards modern individualist property rights. But that could also mean that there is a new notion of property rights, or that it's at least possible. That's the beauty of historical materialism, if there is any, which is things do change. And I think, I personally think that the way that I heard Katharina right now, and maybe because I'm an outsider I can say this differently, is not from here. I don't think there is an internal answer to the problem that you're raising. But just food for thought.
I think I'd like to thank both Katharina and Matthias very much for a wonderful evening, and thank you for your interest and your patience, and come and visit us again soon. Thank you.